Hello, everyone. I'm Haley Hansen. I'm a partner at Husch Blackwell and the leader of Husch Blackwell's Higher Education Group. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the presentation today. If you have any questions during the webinar, please submit them via the question box. We'll try to answer all questions that we get during the webinar. However, if a fuller answer is needed or if we run out of time, we may follow up via email as well. Also, a PDF of today's presentation is available in the resource folder. This program has been approved for continuing legal education hours. In order to report your hours, please click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course number, will be emailed to you tomorrow along with the recording that you can watch again or share as well. Towards the end of the program, be sure to complete a short survey. We do use your feedback to plan future programs and really appreciate any input you can give us. That's all for today's housekeeping items, so let's go ahead and get started. Today we'll be discussing Clery in light of COVID-19, what will change and what will stay the same. Joining me today is Ellen Armentrout. Ellen is an attorney in our higher education practice and helps education clients with all of their compliance needs, including the Clery Act. Prior to joining Husch, Ellen worked for 15 years as an attorney in the General Counsel's office at Michigan State University as the Freedom of Information Officer. We're very happy to have Ellen join us today. So let's talk about what we're going to cover today. First of all, coronavirus considerations. What do we need to be thinking about? And specifically, Ellen's going to walk us through what do emergency notifications and timely warnings look like in light of COVID-19. And then I'm going to talk a little bit about the intersection between VAWA requirements for Clery and the new Title IX regulations and what has changed as you're going to be going back to or some of you will be going back to your campuses either on ground or some virtually as well as you get ready for the fall semester. So with that, let's go ahead and start talking about the coronavirus and Clery guidance. The department issued guidance on April 3rd, which you probably all are aware of, regarding Clery. And some of the major points from this guidance that we're going to talk about in detail today as well, but are very important. Number one, institutions must still issue emergency notifications, even under COVID-19. The second is that the Department of Education does not interpret the requirement for emergency notifications to require regular ongoing updates on COVID-19. And you do not need to proactively identify positive COVID-19 cases. So we're going to break this down. I'm going to turn it over to Ellen to talk about emergency notifications and what this really looks like on your campus. Ellen?
Hi, everyone. Thanks so much, Haley. So like Haley said, we're talking about some things that are changing as well as some things that are staying the same, and I'm going to start talking about that in the context of emergency notifications and then timely warnings and then how COVID-19 coronavirus fits into that along the way. So as you know, an ASR must include an institution's procedures for immediately notifying the campus community about campus emergencies. In particular, significant emergencies or dangerous situations involving an immediate threat to health or safety of students or employees occurring on campus. If a situation such as this presents itself, you must follow your procedures as set forth in your ASR, and then you must follow up with information for the community as needed. So some examples that we see from the Clery Handbook of incidents requiring emergency notification: forest fire that's approaching campus, fire already raging, outbreak of meningitis or norovirus or other serious illness, really important for our purposes now. Approaching tornado or any kind of inclement weather, including an earthquake, gas leaks, terrorist incidents, armed intruders, bomb threats, civil unrest, explosions, and chemical spills. So this is obviously not an all-inclusive list, but I think it's very telling. And I also think it's clear from these examples that these meet the elements of the standard for an emergency notification. One thing that I think is interesting to note as we think about emergency notifications, especially in connection with timely warnings, is that not all of these emergency situations are natural disasters. Some, as you can see, are criminal activity, the example of the armed intruder. I think that is where some people get hung up in the distinction between an emergency notification and a timely warning, so I just want to draw that out as we're thinking about this. Emergency notifications are not just in the context of natural disasters. There are other incidents that require emergency notifications as well. So we're going to present now, excuse me, our first poll question for you all. If a Clery crime occurs on campus and presents an immediate threat to students and employees, both a timely warning and an emergency notification should be issued. True or false? I'm going to give you all a little bit of time to put in your responses here. And it looks like everyone so far has said true. I'm going to give that another few seconds for everybody to get their answers in. The correct answer is actually that is not true. You do not need to issue both an emergency notification and a timely warning based on the same set of circumstances. The handbook points this out on page 6-17, and I like to say this is one of the few times under Clery where you don't actually need a belt and suspenders, you just need one or the other. If you follow your emergency notification procedures, you don't also need to issue a timely warning based on the same circumstances. You do need to keep in mind, however, that additional events could take place as the situation develops, and you might need to file a timely warning in addition to your emergency notification if a further incident takes place. For the example given in the Clery handbook is you have an armed intruder that necessitates an emergency notification, and then when the armed intruder is apprehended by the police, 2 people are shot and wounded. Now that would be a situation where you would have filed the emergency notification about the armed intruder. Then you would later need to file a timely warning about the aggravated assault. So let's look at a helpful chart here that tells us about some of the differences between timely warnings and emergency notifications. So timely warnings are only required when there is a Clery crime. Emergency notifications, on the other hand, are required when there's a dangerous situation, which might include, but doesn't have to be, a Clery crime. Timely warnings are issued as soon as pertinent information is available, whereas emergency notifications are issued immediately upon the confirmation of the significant emergency or dangerous situation. Timely warnings apply when the incident occurs anywhere on the institution's Clery geography, which, as we know, is broader than simply the institution's campus. Emergency notifications, however, are only issued for events on an institution's campus. The examples given by Ed that are helpful, timely warnings come up when there's a rash of burglaries, multiple instances of rape where drugs are being used, date rape drugs, sexual assault, or a robbery where the perpetrator is either not known or not immediately apprehended. Emergency notifications that we've talked about before, things like natural disasters and serious illness, also potentially certain crimes. Timely warnings go to all students and employees, whereas emergency notifications can be narrowly tailored to a segment of the community or a segment of the campus population that's determined to be at risk. Determining what that segment is should be a part of your emergency notification processes as spelled out in your ASR. The purpose of emergency notifications is to allow the community to protect itself against the imminent threat. Timely warnings, the same thing. You do want people to be able to protect themselves, but it's also the thinking is that you want to aid in the prevention of similar crimes. This chart is very handy to have. I recommend keeping it and taking it out to look when you have incidents that present themselves so you can help yourself to make a determination. So now we're going to go to another scenario. The emergency response team at your school has received notification that an employee who has been on campus within the last 14 days has been diagnosed with COVID-19. Should you send an emergency alert to campus? I'm going to give people a little time here. Submit. We're going to see what people say. All right, unfortunately, it doesn't look like the answers are coming through for me. So I can't see what the percentages are. But I can tell you that the answer is yes. You go through the steps to see if it meets the test for an emergency notification. Is it a dangerous situation? Yes. Immediate threat? Yes, if the person has been on campus and there are other people who have been on campus. To health and safety, certainly it's a threat to someone's health. Of students or employees? Yes. If students or employees were in contact with that person and on campus? Yes. So once we know that an emergency notification should be issued, we think about what should be included. Now, I do want to give a little caveat because I suspect that some of you are thinking, but wait, what about alternative ways of notifying the campus community in the context of the April 3rd guidance? I will get to that later, but right now we just know that when there is a situation where there is an identified COVID case on campus that is potentially dangerous for other people there, then you need to issue some kind of alert. So if you're going to issue an emergency notification, what should it contain? So an emergency notification should contain positive, confirmation that there was a positive COVID-19 case, share steps taken to mitigate the risk. For instance, we have washed the room, building, we have included hand sanitizer stations, we have gloves for employees who are going to be in close contact and masks as well. Explain steps the campus community members, should take to limit exposure. This is helpful information that should be included. What you should not do is identify the person who tested positive in your notice. That is not helpful. It's not necessary information most of the time. If you are in a situation where you think it would be important for the individual who was diagnosed with COVID-19 to be identified in the notification, we strongly, strongly recommend that you discuss that with legal counsel before you do so, because there are lots of implications there that need to be considered before you do that. That might come up potentially in a situation, because emergency notifications allow you to notify the relevant segment of the population that's affected. It could be maybe one person, because only one person has the potential exposure to the person who is diagnosed. In that case, it might be more difficult to keep the identity of the diagnosed person a secret, but that's something, again, we would strongly recommend you discuss with your legal counsel. Also, in this notification, we recommend that you encourage your community to go to the available resources, for example, their own healthcare provider, federal websites, the CDC website, to get additional information regarding COVID-19 and safety. You don't then, once you've issued such a notification, you don't have to give regular updates about other people on campus who might have had an exposure or a diagnosis. That is not what ED has said in its guidance. You also don't have to notify about cases not on campus. Say you get word that a student who hasn't been on campus because you're operating remotely, and you have a student who at her home was diagnosed. There is no obligation in that situation to issue any kind of emergency notification because there's not an immediate threat to the campus community at that point. So that's not something that you need to do. Later, I'm going to talk about the other option that ED gives for making this notification in the context of COVID-19 coronavirus. But now I want to talk a little bit about what methods of communication are best for when you are issuing an emergency notification. So how do you get the message out to people? How do you get the message out quickly to your intended audience? The regulations don't say, here's the way you get the word out. There is no prescribed method for doing so. They do, however, recommend developing overlapping means of communication in case one method fails. So, for example, don't just send out phone calls, do an automated message to your community. Send out phone calls and text messages and emails, or perhaps you've got an alarm system. Consider using your institution's website. Consider using your institution's social media outlets, because those are good ways of getting out information, and you can do as many of those as your procedures indicate. If you have an emergency notification procedure that requires students and other community members to sign up, you need to be sure to have your explicit instructions for how to do so included in your ASR. Not just in an email that you send out at the beginning of the school year or anything like that. That also needs to be included in your ASR. So because the standard requires that institutions must ensure that the notifications and warnings can be transmitted quickly to all students and employees, you're not using snail mail, you're not posting posters on trees around campus. Text messages and emails, especially in this day and age, I think are, along with the website and social media, they're going to be the best ways to get the information out. But you can't solely rely on text messaging unless all members of the community are required to participate in the system. The same is true for email. You cannot only use email to send out an emergency notification unless you have provided an email account to all your students and employees, or you have required them to register an email address. So as you're thinking about your procedures and the best way to notify people, keep in mind text messages and email messages are great, but you can't rely on them exclusively unless there is some sort of requirement that people have access to that method of communication, and they have been required to sign up for whatever system you've got in place for making notifications. Another helpful piece of information is that you don't need to include the entire notification contents in a text message that you send out. So one option, if you're concerned about word limits or length of text, things like that, what you should do is, an option for you is to send out a text that tells people to go to another source for information. So you can see this sample we've given here. Check your campus email for an important update. I suspect it would also be fine to include a link that someone could click on to get additional information from their text or from their email. So that's another way to get information out that gets around some issues of limitations on content for a particular mode of communication. So as I mentioned before, Ed in its April 3rd guidance said that schools, when faced with a positive diagnosis of coronavirus that affects their campus, they should issue an emergency notification. An alternative is that they can put a banner on their website. So this is an either or. You do not have to do both. And we think, Haley and I have talked about this, we think this is a great idea for campuses. Even before you have your first diagnosed case, you can put on your website a banner that then links to important information about coronavirus. We know some people who would link then to a particular positive outbreak on campus, or they can just provide information about what the institution is doing to keep people safe, what the cleaning procedures now are, links to local and federal resources about coronavirus to provide helpful information. So that's something that we really highly recommend all schools do. There's no harm in doing it preemptively. So, and there's no reason, so say you've got a banner on your website that you put up in March of this year, students come back in the fall, you have another case, you don't need to do anything. You've already provided the notification that you provide. Now, if this is the route you're going to go, we really recommend that you keep the information on their current, meaning make sure your links are working, make sure that they're links to recent information. But if you've done that, you can, you're all set. You can, your obligations under Clery are done. So let's see, moving on a little bit, we've talked about timely warning some relative to emergency notifications. Timely warnings aren't really an issue in the context of coronavirus because timely warnings present themselves when you are faced with a Clery crime, which coronavirus is not. But I did, since we mentioned it before, I wanted to talk about provide you a little additional information about when to issue a timely warning. So you issue a timely warning when there is, you issue it to the campus community in a timely manner for certain crimes to aid in their prevention if the crime represents an ongoing threat to the safety of students or employees. So how do you know if the crime at issue is an ongoing threat to the safety of students or employees? So this is a list that helps people make this determination. Now, these are not the only factors, but they are certainly factors to be considered. For example, has the perpetrator been apprehended? If yes, then I would say there is not an ongoing threat unless there are other perpetrators. But if you know there aren't, you don't have an ongoing threat. How much time has passed between the incident and the report? If it's a significant amount of time, if you get word of an incident that happened 2 years ago, then I would not say there's an ongoing threat. Were there multiple perpetrators working together? Because if so, then I think and they have not been caught, then you are looking at the potential of an ongoing threat. Was there violence? Were drugs used or weapons to facilitate the crime? This is, that's significant. Was it an isolated incident with a specific targeted victim? If yes, I think you're looking at a less likely ongoing threat. Is there a pattern of incidents? So if you're seeing a pattern in a short period of time, I think you've got grounds to say, yes, there is an ongoing threat. Are there other aggravating circumstances that suggest ongoing danger? This is going to be a very fact-specific analysis, And finally, are there enough details available to determine whether an ongoing danger exists? If yes, and you determine that the answer is yes, then you need to issue a timely warning. So switching gears a little bit, there are a couple other things before Haley starts talking about VAWA and Title IX that we wanted you to be aware of in light of the Clery Act. When coronavirus first hit, we had a lot of questions about what impact it was going to have on Clery compliance. And some of the questions we had were, what does it mean for the crime log? What for the requirements for the crime logs? Are we expected in the midst of all this craziness to keep on, keep up with the 2 business day requirement as we're working on our crime logs? And then the other question, of course, was, will the deadline be extended given the circumstances? Originally, the advice that we got from Jim Moore was just do the best you can to keep the log up to date, and we'll keep you posted about the deadline. Well, what we know now is that the Department of Education has indeed extended the deadline. The deadline is no longer October 1. It is December 31st, 2020, but there are no other changes in terms of the content of the ASR. It should be as, fulsome and robust as it would have been without Corona. I think everyone would do well to have in the back of their head that even though technically you've got until December 31st, October 1st is still a pretty good deadline to be operating under, simply because with all of the craziness that is going on right now, as schools start to think about what being on campus in the fall is going to look like, what classes are going to look like, how all of this is going to impact operations at the school, there are going to be a lot of questions and issues that need to be resolved between, August 15th and December 31st. So as much as you can do with the information that you've got to get your ASR into shape, sooner is better. It's nice to have the cushion, but those are going to be busy months, and so we recommend sort of keeping plugging away as best you can in the meantime. Another piece of information that we thought people should be aware of is that 2 representatives, Annie Custer from New Hampshire and Pete Stauber from Minnesota, have introduced a bill. They introduced it in early March. It's called the Clery Compliance Officer Designation Act of 2020. It requires schools to designate a particular staff member or staff members as Clery compliance officers. There's been no movement on this since March. It's simply been introduced. That's all we know right now. And so it's just something to be mindful of. I don't know that it would make a huge difference on a lot of your campuses, but it is worth noting that it is possible that coming up you will have to designate someone as your Clery compliance officer. Now I am going to turn it back over to Haley to talk about Title IX and VAWA.
So, Ellen, we have had a lot of questions come in about what you just covered. So I think before I switch gears completely, let's just go over some of those questions. So just to be very clear, if you have issued an emergency notification, you've met all of the requirements from the chart that you provided of the scope, when it's issued, the geographic scope, and the information contained on COVID-19, so coronavirus positive case on your campus. If you've done that, then the department is saying that you have notified your campus community of this threat, correct?
Yes.
Yes. I think there was quite a few questions regarding that. So you don't have to then notify for the second case that you have or the third case. And we just want to make that clear. When I talked about those bullets at the beginning, the April 3rd guidance from the department said if you've met the requirement and your first case you have met that emergency notification, then you don't have to send out an emergency notification every time. And I just wanted to be very clear because there seems to be a little bit of confusion. The alternative is if you hadn't had a COVID-19 positive case on your campus, and it can be from employees or students or anybody, then some institutions have already put a banner on their home web page that, as Ellen said, you can click and it gives you links to the CDC and others. So that is your other option. And if you do that, then if you have a COVID-19 positive case in the fall, you do not have to issue an emergency notification because you've met the requirement. And so I just wanted to be very clear because there's been, I think, 24 questions about this. I wanted to make sure that we were really clear. And so I think, I just want to be clear. So like a question that just came in. So if they have another outbreak of, they say they have 15 on their campus they have 15 cases in a dorm and they already have their banner up, under Clery, they are not required to issue 15 emergency notifications. So to make that very clear. Now this may sound counterintuitive to some, because they're thinking that you have this ongoing obligation to continue to inform of each positive case, but that's actually what the guidance says you don't have to do, that came out in April. So I hopefully that will be helpful to people. And again, we are really recommending, and Ellen, please jump in on this, that people create the banner because that gives people information and gives them access to information. Now, this is different than what your return to campus plans probably have in them. And that's a whole different webinar that we've done of what return to campus looks like in terms of working with your local health department and contact tracing and working through your protocols regarding COVID positive cases on campus and contact tracing. Those are separate issues than Clery, and today we're talking about Clery. So Ellen, anything you want to add to that? I just wanted to make sure we were very clear about this.
Yes, thank you. I agree everything, Haley, with what you said. Someone asked a question about where should the web banner be located. I would say on a prominent place on your home page. Haley, would you agree?
Yes, and I actually think at the top of your home page is the best place to put it with the click to the links. And a couple of people have asked us for this April 3rd guidance. We're happy to give it. And then Husch actually put out some sample notification letter, back in April as well as to what this would actually look like. So we'll make sure we attach that as we send out a copy of this webinar, just so we're very clear, because to be honest, I know there's been a ton of questions. We've gotten now we're up to 30 questions, which is great, but this is pretty simple, and you don't need a consultant. You don't need us. You don't need, you just need to comply with, if you've had a COVID positive case already, you should have sent out an emergency notification that met the requirements that Ellen pretty eloquently, put forth for you. If you haven't, we really think you should have a banner. If you don't decide to have a banner, that's fine. But then once you get your first COVID positive case, you need to make sure your emergency notification goes out, and you need to keep your documentation for the department as to the emergency notification. And then a couple questions came in too, Ellen, that I just wanted to clarify about that issue about emergency notifications and timely warnings. And we do tons of work with clients across the country that have Clery reviews and have, as part of their federal compliance reviews through the Department of Education, they have a Clery, maybe a Clery audit, full-blown Clery audit, or even a review as part of their program review of their Title IV programs. And one thing that's really important and something that you need to understand is that there's a very big distinction, and Ellen laid it out for you in these slides, between an emergency notification and a timely warning. And if you don't appropriately classify those types of notifications that you're giving to your campus, and I would even add a third bucket to just things you want to notify your campus campus of but don't fall into an emergency notification or timely warning, the department will really, they'll, in the review, think you don't know the difference between what is required and that you're not executing Clery if you just keep all your notifications in one bucket. So if you say, you know, oh, we've had a rash of cars that have been broken into on the south side of campus, and we want to give you a timely warning to let you know that, you know, and you know, objects have been stolen from the cars, not the cars been stolen, but objects, and we're going to give you a timely warning. That's just a notification that you want your campus to know about. That doesn't meet the requirements of a timely warning because it's not a Clery crime for a timely warning. So make sure you're very clear and consistent about what type of notification you're sending out, and keep those separated in your files so that if the department comes back and says 3 years ago, what types of timely warnings versus emergency notifications were you sending out, you don't just have all of these notifications all together in one area and the department is left to potentially conclude that you don't know the difference between the types of notifications you're required to send out under Clery and the types that you want to send out because you want to alert your campus about something. So be careful about that as well. So I wanted to be really clear there. So again, Clery is different than, and I think somebody just put this in there as well, public health notifications or other types of notifications that are coming out in terms of what's required of Clery. And Clery is fairly basic. You either need to send out an emergency notification for your first COVID positive test on your campus, or that meets the emergency notification requirements, or you need to create the banner. Or if you want to, as Ellen said, the belt and suspenders approach, and you've already sent out your first notification and create a banner just to make sure people have access to your information, there's nothing wrong with that either. So, but it doesn't have to be as complex as some people are making it. All right, Ellen, do you think we answered most of the questions?
I think so. I mean, do you want to address at all what needs to be included in the emergency notification or on your banner? My interpretation is you do not need to be providing specific information about the incident that you are reporting. The guidance simply says that you provide a notification, you provide students and employees a single notification through the regular means informing them about COVID-19 and necessary health and safety precautions, as well as encouraging them to obtain information from a healthcare provider, state health authority, and the CDC's COVID-19 website. That's what you need to include. Haley,
that's what the guidance said. No, I think you're exactly right, Ellen. That's what the guidance says. And again, I think we're kind of making this harder than it is. And my section on Title IX and VAWA is hard, so let's make that hard. This part is not as hard. Let's make this a little bit, a little bit easier in terms of our compliance obligations, because this is something that you can comply with. Several people have wanted to know exactly what to put in the statement. And again, Husch put this out, I can't remember if it was an alert or something that we did. I think it was an alert that we did at the end of March, but I'm sure you've gotten a lot of information from Husch Blackwell. So instead of having to sift through your emails, when you get this email tomorrow, we will attach what we sent out in terms of what we think is appropriate for a banner or for a notification. And we're lawyers, so you should talk to your own lawyer. We're not giving legal advice, but this is information that we think would be sufficient as you're working on these issues. So, okay, with that, I'm going to move on to our Title IX and VAWA. So, in light of COVID-19 and the new Title IX regulations, in which you're all, I'm sure, working on for an implementation of date of August 14th, it's important to understand some of the overlap and I think inconsistency between the new Title IX regulations and Clery, and specifically VAWA. So let's take a look at let's really take a look at what the overview looks like. So the regulations for the Violence Against Women Act took effect in 2015 and really expanded on the content that was required within the Clery Act related to dating violence, domestic violence, sexual assault, and stalking. So many institutions still, when you look back at Clery audits, really struggle with getting this information right within their ASR. So let me tell you the scenario. The person preparing your institution's ASR is feeling pressed for time as the deadline approaches, although now you have some more time, but I know there's a lot on everyone's plate right now. That individual comes to you and says, I think to save time and for sake of completeness, I'll just include our Title IX sexual harassment policy in our Clery report in the VAWA section. And since it is our 2019 report, my plan is to include our policy that was in effect in 2019. So my question to you is, how do you respond? Do you say, and hopefully you can answer this, great idea, go for it. Sounds good, but don't include the entire policy. Sounds good, but use the 2020 policy instead. Or, I think we need to talk. So I'm going to give you just a minute to answer this question. Submit your answer. Pick the one that you want. And then I will show you the responses. And part of this, hopefully, you learned from Ellen's slides as well. All right, so let's see. So not too many thought it was a great idea, so that's good. Sounds good, but don't include the entire policy. Got a few. And the vast majority of you said, we need to talk, which is the correct answer when you say we need to talk about this. So the 2020 policy would need to be included, but why else do you need to talk about whether or not this is a good idea? Number one, you're going to need to talk because current policies have to be in your current ASR. So that is really, really clear. And it's right on contained within the Clery handbook that says that statements or descriptions of your policies must accurately reflect your institution's current policies and procedures at the date that you're publishing your annual security report. So make sure that you understand your ASR published this year needs to include your current policies. Also, you need to make sure you are individually answering all of the VAWA requirements within the ASR, and your policy may not do that. It may not answer all of the individual requirements, and so let's go through that. And when we see, other than misclassifying crime statistics as the number one area in which an institution can be fined, in the top 5 for sure is policies that are not included specifically regarding the Violence Against Women Act. So this has been a big area of noncompliance for lots of schools. So, again, it's a very, very common mistake, and it inevitably leads to too much information when you include your entire policy in some areas and not enough information in others. Now, people have asked me, could we, as Ellen stated, the belt and suspenders approach, could we answer individually all of the VAWA-related questions for ASR and then include a link? And you can do that. You can include more information if you want to. You just have to understand those questions have to be independently answered outside of the policy. So the link to the policy does not satisfy your requirements under VAWA, but it can be you can add it as additional information if you want to. All right, so let's really break down and talk about the statements on educational programming. What we see are the big issues and some of the things that are going to really be affected as we look at the new Title IX regulations. So first of all, you must do all of your primary prevention programming and ongoing prevention programming for students and employees. And you have to actually have a statement that the institution prohibits VAWA-related offenses, the definitions in applicable jurisdictions, so in your states in which your institutions are located, definitions of consent as it relates to the applicable jurisdiction, descriptions of safe and positive options for bystander interventions, again, all within your educational programming, and information on risk reduction. So as part of the VAWA statements, whatever your state law definitions are, and I've just given Missouri as an example, and I didn't even provide all the definitions, but these are types of things that would need to be included for your VAWA definitions, just an example. Also, you need to include for the Violence Against Women Act in your ASR the procedures victims should follow. So the importance of preserving evidence, to whom the alleged offenses are supposed to be reported to, and the options. So contacting law enforcement, declining to contact law enforcement, and being assisted by the institution in contacting law enforcement are all options that the victim would have in determining how they want to move forward. And then the rights and options of the victim and responsibilities for legal protections as you move forward. And we're going to talk about that overlap between what your rights and options document looks like and how you meet Clery requirements, and then as we talk about the new requirements under Title IX, supportive measures documents that you have to provide, and what the differences of those are and how institutions are handling that situation in terms of if you have a Violence Against Women Act crime, if you have sexual assault, dating violence, domestic violence, or stalking, the information you're going to provide to independently make sure that you have met Clery and VAWA at the same time providing supportive measures that cannot be disciplinary or punitive under the new Title IX regulations. So speaking a little bit more about that will be important as well. All right. Institutional statements, other institutional statements that have to be included in that are commonly missed are, again, statements regarding community resources, changing to academic and living situations, confidentiality, and what that looks like, and how the institution will maintain record keeping without personally identifiable information. All of that information, again, has to be in your rights and options document, which also then has to be in your annual security report. And so I think it's important to really include that information. All right. So let's talk about the rights and options document must go to not only students but employees. So actually the new Title IX regulations, as you know, apply to both students and employees. And so this may make it a little bit easier. Some of our institutions, though, had taken the approach through VAWA and the rights and options document, which I really support, that they had a separate document for victims that were making a complaint of sexual assault versus domestic violence, dating violence, and stalking. And why that was important is because we'd gotten some feedback from victims or complainants, maybe under your policies, that had said, if you hand me a document that says at the first part of it where I can get a SANE exam or rape kit done, and I've complained about stalking, and and I'm looking through this multi-page document that talks about all the places that I can get, this type of medical assistance or medical advice for rape, it makes that victim or complainant feel like you don't understand what they're making their complaint of. And so there's nothing wrong with, as long as you're meeting these requirements in your rights and options document, separating out ones that you may give to a victim of sexual assault versus one that you provide for dating violence, domestic violence, or stalking, so that you are really meeting that complainant or victim's needs with the document versus providing more information, granted, but information that they think may not be applicable, and so they may believe that you're not as attuned to what they are complaining about. And again, it also has to include the procedures upon which that you will follow. One of the big keys that I want to talk about is this procedures issue, and I actually went a little bit quicker over it in the slides, so I'm sorry. But the procedures is one that we find so many schools miss regarding VAWA offenses, and it has to include that each disciplinary proceeding that will be used to resolve a complaint. So you have to include in your ASR what those disciplinary proceedings are. So let's say that you have a situation of sexual assault, and how now under your new Title IX regulations that is going to be your formal complaint process. So you will likely have, as part of that overall process, you'll have an investigation portion of it that is a fact-finding investigation, and then your process includes a hearing, either with a hearing officer or a hearing panel that will be the adjudicator or decision maker as to whether or not, and I think you can set it up, two different ways. Number one, whether or not your Title IX or your sexual harassment policy has been violated, that they make that decision, or not only decide if it's been violated, but also decide a sanction. And so all of that has to be laid out within the ASR. So these questions have to be independently answered. The standard of evidence used in the proceeding has to be independently answered within the ASR. So it's going to be important to make sure that all of these institutional statements are going to be, and I'm going to go back just a slide here so you can see this, but that all of these statements would be provided to all of the individuals receiving the annual security report. And then the last or one of the most important bullet points that we find missing so often in our annual security reports is all possible sanctions following the results. And so that means for not only students, that means for employees as well. And a lot of our Title IX or even sexual harassment policies love to use the language, because lawyers help write them, that, this would be up to and including termination if you're an employee, or up to and including, we love that language, expulsion. That doesn't satisfy the requirement under Clery. You actually have to have all possible sanctions, and it's very, very important that you have that information regarding in your ASR, or that could lead to a violation if you had a Clery audit or a Clery review, or also if you have a program review from the Department of Education. So I only have a few minutes left, and unfortunately for some, but good for others, I could probably talk on this topic for quite some time. I also wanted to just point out some other considerations. Number one, jurisdiction outside the United States for Title IX. So if you have foreign campuses, if you have, or separate campuses that are in foreign countries, if you have non-campus property identified that's outside the United States, Title IX does not apply. So you're going to have to identify what in your conduct policies will apply if there's behavior that occurs outside of Title IX jurisdiction. The regulations essentially tell institutions that after the regulations take effect on August 14th, you are not allowed to process a sexual harassment Title IX claim of something that happens outside of the United States. Yet you still have Clery responsibilities for the Violence Against Women Act for people that are participating in your education programs that you have control over on non-campus property or even separate campus property. So consider what your policy looks like under your conduct policy to address those issues that are happening outside of the jurisdiction of the United States, because you still must satisfy all VAWA requirements. And don't forget that as you're putting together all of your policy changes. Also, again, I talked about this overlap between the rights and options document and how that information has to be provided, and then supportive measures. So the new Title IX regulations say supportive measures are non-disciplinary and non-punitive. They are supportive or accommodations to preserve access to education programs and activities, and they are reasonably available without fee or charge, and they are not unreasonably burdensome on the other party. So supportive measures, think about, how you issue, especially if you put it as part of your rights and options document, that you could issue a no contact order in a case of a sexual assault. It has to be non-disciplinary and non-punitive. So think about that. If you only issue a no contact order on one party and not the other, if you are not allowing them to some spaces because they can't be at the same space at the same time, is that then disciplinary or punitive under Title IX? So think about, how supportive measures really differ from your rights and options documents under Clery, and now the obligation to provide both. So here's an example of supportive measures: counseling, of course, academic accommodations or housing accommodations, security escorts, leave of absence. If you're going to have a leave of absence, make sure that you're also notifying students of their rights to work with your Title IV office, federal financial aid, so you can make sure that you've satisfied those obligations as well. Increasing security or monitoring in specific areas. Mutual no contact orders where implicated by the facts and where that could be looked at as non-disciplinary to one party or another. And I think the other thing that you need to make sure of is that, again, we've had some individuals that have complained that mutual no contact orders that have no end are punitive in nature as well, and so be careful of that as well. If you're just putting out a no contact order that doesn't have any end to it, it just goes on as long as those two individuals are still at your campus, that could be an issue as well. And modified work schedules. So I've given us 1 minute for questions, Ellen, but we did answer a whole bunch of questions from your presentation. So were there more that came in during mine that we need to answer?
There are a couple. Someone asks, if you list all the individual sanctions, can you still include the up to and including language?
You are not supposed to, no. You're supposed to, it has to be a list of just the sanctions. And so you can include that within your policy, but not within the ASR, because the ASR is supposed to put somebody on notice of all the things that could happen as a result of your investigation. So, again, I would still include it in your policy language. I would not include it in your ASR.
Someone has also asked about getting crime statistics from countries outside the U.S. and how they find that very difficult. For Clery purposes, you still have to give it a try. That has not changed in light of the new Title IX jurisdiction, correct, Haley?
Yeah, that's correct. You still have to try, but you just have to make good faith effort. So if you send a letter to try to get crime statistics, I can't tell you how many schools never get a response to their inquiry, but you've kept a document that you've sent that letter. Or I had one that went to Venezuela, and they said, we're not going to answer your request for crime statistics, but we're going to tell you don't have your students go in this area. It's not good for citizens of the United States, which I thought was an interesting response. So, at least they responded, but they would not provide any crime statistics. You've tried, though. So I think that's really important that you document that you have tried to collect those crime statistics. And this year, because you've been given more time too, I think, having that documentation is going to be extremely important.
And one more quick question, Haley. Someone asked if the Department of Ed will allow extensions to the implementation of Title IX that go into effect on August 14th.
No, and there are lawsuits right now to try to stop the implementation date. A judge in one of the lawsuits ruled recently that and asked for more information, but so far we have seen nothing that's stopping the implementation date. I will tell you, I have predicted everything wrong when it comes to Title IX, and I should know that better because I predicted the sex of both of my children wrong as well, and was wrong each time. So my prediction is that the 14th will stand and there will not be a nationwide injunction. I say that, and then of course you know what's going to happen is, on the 13th there'll be a nationwide injunction of the Title IX regulations. But no, the department is not going to. The department is very firm on that date, even after begging and pleading by many groups to provide more time to put this all in place. So that's going to move forward. But from the department's perspective, the court's perspective, we'll have to wait and see. But I would predict there wouldn't be a nationwide injunction. So I think we've answered most of the questions. We're a couple minutes beyond 1 o'clock, and I apologize about that. But I did just want to mention to everyone that you get information about our Clery compliance tool set, and if you have questions, Mary Jones in our office is fabulous and would be happy to answer any questions. I know a lot of our clients that are on this call already use the Clery compliance tool set, and as you know, we're migrating you over to a new and improved system and excited about that migration in the next couple of days as well. So happy to help you with all your compliance needs. So with that, I wanted to say thank you to everyone for joining us today. We hope the information was helpful to your institution. As a reminder, this program has been approved for legal education hours. To report it, click on the CEU icon at the bottom of your screen. A certificate of attendance and the course numbers will be emailed to you tomorrow, along with a recording of the webinar for sharing and watching at your institution. And we'll also include our notification language, as we talked about as well, in that when we send that out to you tomorrow. Also, be sure to complete a short survey that will provide us feedback and help plan future webinars. And with that, I'd just like to thank Ellen. I'd like to also thank Emily and Mary, who work behind the scenes on all of our webinars, and what a great job you guys do. And that concludes our webinar. Thank you.